Thank you for joining us this afternoon. This is actually the third and the final installment of our series with Deloitte Private on wealth management centered on the Labuan offering. And of course, as they say, we've always keep the best to the last. And today we've got a very clear and fantastic, we've got a very clearly fantastic panel lined up later, but also presentations on the Shariah aspect of wealth management. I think Labuan's leadership in Islamic Islamic financial services is bar none. But in wealth management especially, we have been very innovative and very cutting edge in the kind of solutions that we offer Islamic Sharia compliant families. So, I think in the presentation to come, you will find that there is discussion about our Islamic Waqf Foundation, our Islamic Foundation, and, Islamic Trust, of course, is also available. So just to remind everyone that what will happen is that we will have presentations from Farah and Fariz in a minute. And after that, please stay on and join us for our panel, where we will discuss certain other nuances with regards to planning in the Sharia compliant way. And also we hope to have some very exciting and challenging questions from all of you with regards to the structures that we have and how we look at the future of Sharia planning in Malaysia and beyond. So with this, can I please invite Farah Deba, who is the chairman of STEP Malaysia, to deliver her presentation, followed by Faruk. Thank you.
Thank you, Farah. Thank you very much. Thank you everyone for joining us. I've been asked to talk about Sharia succession planning for global families. If you look at the topic, there are three limbs to this topic. The first one is it having to be Sharia centric. Yeah, that means we have to talk about Sharia law and how it's being implemented worldwide. Secondly, succession planning. If you talk about succession planning itself, there's already a topic on inheritance and succession. That's a very big topic to begin with. You have also to deal with the issues of the process of inheritance and how it goes on to distribution. Yeah, and we're talking about the third limb is families around the world. So that is the international aspect of succession planning. So there's really quite a lot to say within these 20 minutes that I'm given. And so let me just try to cover as much as I can. Fariz will be talking about the tax and the financial costs, when it comes to succession planning structures. So I will leave that to Fariz. Right. I think as an advisor, the fundamentals of succession planning must be properly appreciated. Yeah, in Islam, the concept of wealth is a very holistic approach. It covers worldly matters, it covers afterlife, and the continuity of the benefit to the society at large. In Islam, profits are encouraged, contrary to popular belief, because of the issue of riba and everything. A lot of people think that we shouldn't be living in luxury or but in actual fact, business is allowed in Islam. So the concept of wealth in Islam is premised upon a hadith narrated Abu Hurairah alayhi salam, which is when he was reported that Rasulullah sallallahu alaihi wasallam mentioned that when a man dies, his good deeds come to an end, except the three things: his amal jariyah, which is his ongoing charity, beneficial knowledge, and the righteous offspring who give dua to him. So it's the continuous prayers, continuous beneficial knowledge, continuous good deeds, which benefit the public at large. So the meaning of this hadith is actually twofold. The deed of a Muslim ends on death. So the date of death is very important. That's when the law of inheritance falls. Before that, there's no such thing as the law of inheritance. And likewise, the good deeds of a Muslim also ends, except those three deeds. So if you look at it, that is the concept of wealth planning in Islam. Now, it starts with the process of wealth creation. The process of wealth creation itself, you must have halal assets, and you accumulate by way of making profits and transparency, and your investments are halal. then you go into protection. What is protection? In Islam, if you there's also another hadith which says that it's better that you leave your heirs rich than let them beg from amongst your neighbors. So the idea is actually when you create wealth, you must provide for your family first. That's why there's this concept of estate planning. So it is highly encouraged that, you know, Muslims, contrary to popular belief, must look into estate planning, must provide for their children and families. Whether you like it or not, there are basic principles in Islam that as far as distribution is concerned, distribution after death, yeah, one of which is you cannot exclude your parents, because that's the duty of a child to their parents. You cannot exclude your children and your spouse. So those are very, very basic basic principles of Islamic law of inheritance, and that must be taken into consideration when advisors advise Muslim clients on their succession planning. And then the issue of distribution, how is it distributed? Is it short-term, is it long-term, or is it in perpetuity? It all has some religious aspects to it as well. Yeah, so that is the holistic approach. So we can go to the next slide. Right. So basically, advisors need to understand the Islamic law of inheritance. Islamic law of inheritance in its purest form, which is the Hukum Syara, is complex because and it is derived from the 4 sources of law, which is Quran, Sunnah, Ijma, and Qiyas. You know what Quran is? That's the divine, our book, the divine book. Sunnah are the prophetic practices of Rasulullah. Ijma is consensus of Muslim scholars. That means you need the scholars to agree on a point, on a legal point of view. And then Qiyas is analogical reasoning to derive at a juristic ruling. So these are how Islamic law is being formulated. Yeah, these are the rules laid out, and they are complex and they are very context specific. In Islamic law, there's no such things as binding precedent. Every case is decided on its own merit. Every case is different, and every case is actually very, very factual. So there's a lot of difficulties, and it creates a lot of confusion, because one person will come to you and say, my neighbor said this advisor said this, and this, I have drafted my will, I have prepared a trust. And then, you know, when a client comes to meet another advisor, and they get confused again, why somebody have a will like this, why you have a power of attorney, what is a grant of probate. So they do not understand the real effect of the real concept. So conceptually, it has created a lot of confusion. It has created a lot of misconceptions. So if I could just address the basic issues on inheritance law, is the rules of distribution, which is known as Farah, to another layman, non-Muslim, is actually is a forced heirship rule. Yeah, and this is not it's not unique to Islam. It is as far as I understand, I have clients who are Danish. There's also such laws, and even Germans, there are also such laws whereby there is forced heirship rules. So certain people are not allowed to be disowned from inheritance. As far as the concept of gift inter vivos, in Islam we call it hibah. It has been overly used and overly rated, but to understand it is the simplest way to understand it. It is just a gift of an asset to another, which is done during lifetime. The concept of wasiyah, which is a rule of bequest, and also the document which you call the wasiyah, or in English is will, is itself the testamentary instrument. So there are 2 parts to it when you use the word wasiyah or you use the word will. But it's easier for you to understand that wasiyah, in fact, is a rule of distribution after death. Yeah, those rules are subject to the fact that it is after all liabilities have been deducted, then you have a Muslim can bequeath 1/3 of their assets of their estate to non-heirs. So if a will is drafted in such a way that I would like to give, the simplest example will be, I would like to give my house to charity. Number one, we have to first value whether the house is up to wanted value of the estate. Number two, you have to determine whether that charitable organization is your heir or not. Definitely, if it's a charitable organization, it's not your heir. Yeah, that's number one. That's rule number two. How it gets more complicated when you read a will and then that is written as, I would like my son to take my car, for example. I want him to take my businesses and be the CEO, and basically he takes charge of my entire estate or my entire business. That is where the confusion lies, and that is where a lot of the dispute arises as well, because it's stated in the will, which is the testamentary instrument. So then the issue is whether that clause valid or not, you know. So we have to be very, very clear when we help our client to when we draft our client's will. What is it that you want to put? Is it a proposal, or does it fall within the bequest rule? So that alone have created a lot of confusion amongst Muslims and also Sharia advisors. Yeah. So in Malaysia, we have the Sharia court. So the court have actually been have to decide on whether a clause falls within the Wasiyah rule, or is it a testamentary instrument, which means that generally it's valid, save and except for probably certain clauses. So there's a lot of dispute about it, but I think it all emanates from the fact that, you know, people misunderstand and there's a lot of misconception about it. Then you also have this issue about power of attorney, whether you can transfer an asset using power of attorney, or and which is confused with the lasting power of attorney that is available in Singapore, that's available in probably in the US. We in Malaysia do not have a lasting power of attorney, and and we can't use that. So Malaysian law is slightly unique in that sense, yeah. And the issue of grant appropriate letters of administration, whether if your will is if your will is being invalidated, what happens? Do you apply for probate, or do you now apply for letters of administration with a will annex? So these are real issues. These are problems that cost our Muslims clients a lot of money. So next slide, please. So in order for us to understand succession planning well, we have to be aware of the jurisdictions that our clients are located. So the fact that family members can be physically spread out all across the world, but are internationally connected, it just shows that as advisors, we must take into consideration local laws, culture, tradition, practices, and the uniqueness of the domicility of the client. So the law of domicile is very, very important in succession planning. I think in most of my talks, I've always said that, you know, whether you draft one will or multiple wills, it all depends on the law of domicility. And most advisors should be aware of this by now. Yeah. So we have to understand that the jurisdiction nowadays is not just separated by common law system and civil legal system. We need to know the specifics. How would the UK court view a Muslim's will, which has got Islamic principles drafted into it, and how would they enforce it? How is it implemented? So we have seen that, you know, the UK wills, which is governed by with their own Wills Act, but the Islamic law principles are being put in and drafted into the will. And it remains to be seen how the court is going to construe that, whether expert evidence has to come in with regards to Sharia law principles. Yeah. And in Malaysia, for example, the value of renunciation and disclaimer of a beneficiary, it may attract stamp duty. So that's another factor that in succession planning or estate planning that we must take note of. I think Fariz will be able to assist you here later. There's also RPGT issues. So for Muslims, right, where do you go in actual fact to determine ashib? In Malaysia, we have Sijil Fara'id, or certificate of Fara'id, and it is issued by the Shariah court. If you are in a country where there is no such thing as Shariah court, then who validates the list of assets? Identifying heirs in Islam is very, very important because it's important because only legal heirs can inherit, which also sometimes can lead you to other issues, whether the child is adopted child, the child is someone born out of wedlock, and these are very important. And if there is no transparency or full disclosure, you could create a lot of other problems as well. Yeah, in particular, in terms of not just inheritance, but also in terms of muhrim, when we talk about muhrim, we're talking about who will then be the wali, whether wali means the person who marry you off, who are the rightful person. If your marriage is not properly solemnized, yeah, the akad is not properly done, you could have other problems as well. So to me, Fara'id is a very important and a very crucial document. Our certificate of Fara'id is a very crucial document because it helps you with a lot of other things as well. Yeah. Next, please. And the issues faced by Muslims globally, these are very valid concerns. If you notice, most parents want to have equality, division of assets must be daughters and sons to have equal rights. And at the same time, they wonder whether, if they were to have certain wishes, would that actually, can that wishes be implemented? Would it create more dispute amongst the family members, and who will succeed? The issue is inheritance of assets and the right to succession are actually two separate issues. The rainmaker to a business may not be may not have the biggest chunk from the inheritance. Yeah, so that is based on capability, but how do we actually balance that out? And also in Islam, there is also this concept that you also don't want the family to sort of like break up, because you also want your children to pray for you. So you don't want to let your children be upset with you, nobody will pray for you. So these are all the multifold conflict, parents and a lot of our clients are facing. It doesn't matter, in fact, whether you're high net worth or you are not high net worth. Yeah, I basically handle any kind of estate, right from the small estate to the big ones as well. So basically, in Malaysia, just for your understanding, in Malaysia alone, we have two legal systems. We have the civil law and the Shariah law. Yeah, and we also have civil court and the Shariah court. We have also another classification, which is the federal law and state laws. And trying to match this is not easy because the practices are different. The requirements of the different judges in different courts are very different as well. And if you think about the other Muslims, our Muslim brothers and sisters who are not in Malaysia, if they're outside in US or in the UK, the uncertainties in the implementation of their Sharia principles within their documentations to be implemented in their jurisdiction is another headache. So it is fair to say that most Muslims want a standard simplified products. They want to know what is the best practices. But I say that unlike will writing, it's not easily available for Muslims, but there are some best practices. One of which is, I think you will have to look at when it comes to wealth management. Lab1 have got some structures that we can use and compare with others. Yeah. So for example, for international families, you may want to look into Sharia compliant Labuan structures. Labuan is not the only jurisdiction who uses trust and foundation. Next slide, please. So generally, trust and foundation are very popular amongst Sharia advisors and also the clients. Yeah. However, in Malaysia, actually we have quite a number of options as far as Muslim families are concerned, whether you are Malaysian domicile or you are non-Malaysian domicile. Basically, especially for, if I were to start with Peninsular Malaysia, there's quite a number of structures that you can use, but particularly in Labuan, we have the Labuan Trust and the Labuan Foundation. Now, there's we also have the Labuan Islamic Financial Services and Securities Act 2010, which also endorses Islamic type, Islamic-based trust and Islamic-based foundation. So we get, our law is derived from that. So the provisions of Labuan Trust Act and the provisions can be used for any trust setup, and the provisions of Labuan Foundations Act can also be used for any Labuan foundation setup as well. I would like to think that everyone who's listening to me have got some basic background of what a trust is and what a foundation is. If I can just put it in a nutshell, trust is established by a settlor to give specific property to a third party to be held for the benefit of others. So basically, trust means the settlor settles the property into the trust and to hold it in trust for a third party. The third party are the beneficiaries, okay? And that the basis of the relationship is pursuant to the trust deed or the declaration of trust, whichever, yeah? And there's a fiduciary duty which is put upon the trustee. Now, the difference between a trust and a foundation is that the asset is legally owned by the trustee, but it is beneficially owned by the beneficiaries. But as far as foundation is concerned, a foundation is an entity, a corporate entity of its own, having its own separate legal rights. It can sue and it can be sued. So unlike a trust, the burden is on the trustee. So you have to find a very good trustee. You must know your trustee well. You must trust your trustee too, otherwise nothing moves. And as far as ownership of assets, it is legally and actually beneficially owned by the foundation. So basically, trust and foundation are generally used as a tool for wealth management, yeah, by quite a number of Muslim clients. Next page, please. So in Labuan, we also have Labuan Islamic Trust. It is done pursuant, is incorporated pursuant to the Labuan Trust Act. And basically, the difference between a conventional trust, which is also available to Muslims, in fact, yeah, is just that if a client decide to form an Islamic trust, the settlement of the asset from the settlor to the trust must be done via hibah. There's another cardinal rule of hibah. Hibah must be done during lifetime, and it must be perfected during lifetime. So if you have the hibah, basically we'll have to do a hibah document to transfer the assets into the trust. So basically the asset doesn't belong to the settlor anymore. Farah law should not apply, basically. However, it is all dependent on the trust deed, yeah, whether the settlor reserve his powers to manage the trust and things like that. So that's another discussion altogether. But basically, what is available out there is that there is a Labuan Trust that available for Muslims, whether conventional or Islamic. It's just a matter of making sure that the assets are Sharia compliant, is managed in a Sharia compliant manner, operationally and also administratively. The other part of this, which is the wasiat. Wasiat, as I mentioned just now, it relates to the remaining as wealth of the settlor. that is the one that is, if you want to say, is fara'idable. Yeah, it falls within the law of inheritance. What have been transferred validly and absolutely into the trust should not be subject to inheritance law. So next. And we also have the Labuan Islamic Foundation. What makes the Labuan Foundation Islamic is that its objects, purpose and activity is in compliance with Sharia principles. Again, the asset must be halal, investment must be halal, there is all the Sharia compliant issues about how the money is being used is all, that is all must be Sharia compliant. Yeah. So in a foundation, the basic structure of a foundation is that the founder will endow the assets via hibah to the foundation, which has been incorporated earlier. The asset belongs to the foundation. Pursuant to Section 11 of the Labuan Foundation Act, it says that the moment the founder, the asset is transferred from the founder and endowed into the foundation, it ceases from becoming the founder's asset. That's number one. Number two, but it also does not become the asset of the beneficiary until distribution. So these are, so basically, if you look at estate planning, it's actually more estate planning than succession planning. This is one way to look at it and to use as a structure. As a succession planning, what it means is that basically, if you have transferred your shares into the foundation, then the governors, the governing body can dictate and basically have control on how the assets are being managed. The assets could be anything, could be bank accounts, could be companies, could be properties. So basically, there are two structures available for Muslims: trust or foundation. But there is something else that which is a bit even more unique to Labuan, is that we have our own corporatized Waqf, which is commonly known as Lab1 International Waqf Foundation. It's known as LIWF. Yeah. What makes this different than normal Islamic foundation, the normal Labuan Islamic Foundation that I mentioned earlier, is the fact that the establishment of LIWF is based on principles of Waqf. The principles of Waqf is specific. Basically, it must be a benevolent gift in the name of Allah. It belongs to him, therefore, and the legal asset belongs to the trustee. It is not inheritable. It cannot be gifted, and it cannot be sold. Assets must be preserved. Basically, the capital must be preserved. And if it needs to be replaced, only the Sharia advisor can, with the Sharia advisor's approval, yes, you can do that. So only the benefits are being distributed to the beneficiaries. Income and benefits. So the type of asset that can go into a Waqf could again be properties, rental income, can be distributed. For example, shares and sukuk. So the dividends and the benefits from there, arising from that, and the profits can be distributed to the beneficiaries. The difference between a trust and foundation, and for this matter, Waqf, is that the beneficiaries are not entitled to the asset nor the benefit unless and until it has been distributed to them. So it is also not the beneficiary's asset. It's definitely not their legal asset, but it is also not their beneficial asset. So therefore, Waqf, LIWF, serves a lot of benefit as far as Muslims are concerned. I just checked today, there's about 16 Waqf foundations that have been set up and registered with LFSA, but those are the ones that are registered and made known to the public are the ones that solicits public fund. The ones that have not, that do not require public funds are not out there for you to see. But I am aware that the past 1.5 years, quite a number of foundations have been LFSA have registered quite a number of foundations. I myself have registered about 3 past years, but for non-Muslim, there are a few who are thinking about it, and there are quite a number of Muslim clients who are looking into Labuan International Waqf Foundation and also the Islamic Foundation for a start. Yeah. So, so basically, in terms of if you look at what Labuan has to offer, it's very, very flexible. Next slide, please. It's very, very flexible in terms of purpose and object. There are 4 types of Waqf that we can do. Waqf, which is this is called the self-dedicated Waqf, whereby the Waqf income is retained by the founder, and after his death, it goes for charitable purpose. There's a second type Waqf, whereby the foundation, the beneficiary of the foundation gets to enjoy for the benefit of the community. Yeah. And thirdly, family Waqf. This is family Waqf is no longer available in Peninsular Malaysia. So this is a good way for excuse me. This is one tool which is attractive for Malaysian domiciled Muslims to actually look into. Waqf income can be reserved for families, and it can go to charitable purpose when none of the family members exist. The 4th type of Waqf is the joint Waqf. This is where the Waqf income, the benefit of the Waqf itself can be shared between family members and charitable purpose, and for charitable purposes. So basically, you can see that whatever it is, there's quite a number of options available for Muslims globally, and particularly for Labuan. Residents can incorporate trust or even foundation in Labuan. It also applies to qualified persons. So basically, almost anybody can actually can use Labuan as a tool for their wealth management planning. So I suppose that's all I have to say. Thank you.
Thanks, Farah, for the extensive explanation on the succession planning for global families in Labuan. Right. Okay, Assalamualaikum and good afternoon, everyone. My name is Fariz, and I'll be spending the next few minutes with you to share with you on some income tax or the tax considerations when it comes to having your wealth or succession structure in Labuan. We have just now Farah discussing about Lab1 International Waqf Foundation. Right? So in essence, it is a foundation. The unique thing about the Malaysian tax law, even in Labuan, is that there's neutrality between the conventional as well as the Shariah compliant taxation. And when we talk about Labuan International Waqf Foundation, the essence of it is it's a foundation. So for Muslims who wanted to consider Labuan as a destination for their succession planning and also for wealth structures, a foundation is one of those common vehicles that will be used. So I will not touch base on what a foundation is. I think Farah has explained extensively before. So if we look into the tax implications, we have to look at various aspects, from the Waqif, the founder of the foundation, the beneficiaries, as well as the foundation itself. So when I refer to the Labuan International Waqf Foundation here, it also, the implication also applies to a normal Islamic foundation, right? And when the founder Waqif endow the assets through Waqaf, or even in situation through Hibah, right? There will be tax consideration that needs to be considered. First is on the real property gains tax. Okay, and if the assets being endowed consists of real property, well, real property gains tax will keep in, right? And for other types of assets, for example, marketable securities or even shares, right? They are, in addition to real property gains tax, there are stamp duty implications, right? As we know, there's ad valorem rate on marketable securities of 1% to 4% on the transfer value of the assets. Okay? So on the other hand, the beneficiaries will receive income from the foundation or the Labuan International Waqf Foundation, right? So the distributions of income are generally exempted from Malaysian tax, right? But however, for non-residents beneficiaries, they will need to satisfy their own tax liability in their respective jurisdiction of tax residence. So for example, in Australia, or if the beneficiary is in Australia or in Japan, the tax consideration in Japan will need to be taken into account, since the distribution income from the foundation would constitute the income of the beneficiaries in those particular jurisdictions. Moving on to the next slide. So another angle is from the Labuan International Waqf Foundation, or the foundation itself. The foundation, the taxability on the foundation would depend on what are the properties that have been endowed by the founder into the foundation, right? If we're talking about Malaysian properties, and these Malaysian properties derive income, for example, if the real property and the real property derives rental income, or even bonds or securities that derive interest income, or dividends, or shares that derive dividend income, this Malaysian property would be subject, the income generated from this Malaysian property will still be subject to tax under the Income Tax Act. No doubt that in Labuan there is a Labuan Business Activity Tax Act, but when it comes to foundations that have Malaysian property, those income from the Malaysian properties would still be subject to tax under the Malaysian Income Tax Act. So what is a Malaysian property here? So in a nutshell, Malaysian property means any property which is situated in Malaysia, and property includes assets of every kind, whether corporeal or incorporeal, movable or immovable, tangible or intangible, however acquired, and also includes legal documents or instruments in any forms, including electronic or digital, evidencing the title to the interest in the assets, right? This includes bank checks, money orders, shares, security bonds, and so forth. Okay. And on the other hand, if the property in the Labuan Foundation or the Labuan International Waqf Foundation consists of non-Malaysian property, real property in outside Malaysia, right? So this income will be subject to tax under the Labuan Business Activity Tax Act. Okay, and how it, well, generally when we talk about foundation for succession planning, the business activity will be considered as a Labuan non-trading activity. Right? For Labuan non-trading activity, depending on it meeting the substance requirements, I will go into a deeper discussion on substance requirements in the next slide. Well, depending on meeting the substance requirements, if the vehicle use or the foundation meets the substance requirements, then there will be no tax in Labuan, right? And in any event, if the substance requirements are not met, then 24% of tax will kick in. Okay? And if somehow, although it's unlikely, somehow there's trading income derived by the foundation, it will be still taxed at either 3% or 24% under the Labuan Business Activity Tax Act, again, depending on satisfying the substance requirement. Okay. Moving on to the next slide. So Labuan Islamic Trust, okay. The tax treatment when it comes to Labuan Islamic Trust is very similar to the tax treatment of a Labuan Foundation. Right? In the case of a Labuan Islamic Trust, where the settlor settles and endow the property into the Islamic Trust, again, we need to look into what are the assets that are being settled into the Islamic Trust. The types of assets, for example, real property, there will be real property gains tax, and other types of securities, if there will be stamp duty that will be applicable on the transfer of shares or even real property into the Labuan Islamic Trust. Okay? And similar to the Labuan Foundation, the income of the Labuan Islamic Trust will be taxed depending on where, on whether whether the trust property or the trust asset is a Malaysian property or a non-Malaysian property. Again, for Malaysian property, it is still subject to tax under the Income Tax Act. Income derived from non-Malaysian property is subject to tax under the Lobata, right? And well, generally, income from investment holding is not taxable. If the Labuan Islamic Trust fails to comply with the substance requirements, there are 24% tax that could be applicable. Okay? And for the beneficiaries, similar to Labuan Foundation, generally the distribution made by the Labuan Islamic Trust to the beneficiaries in the form of probably dividend, interest, or even rental that is received by the Labuan Islamic Trust would generally be exempted from Malaysian tax. And on the other hand, again, for non-resident beneficiaries who are residing outside of Malaysia and are taxed under the respective jurisdiction, so certain tax consideration needs to be considered in those particular jurisdiction in respect of the distribution the beneficiaries receive from the Labuan Islamic Trust. Next slide, please. Okay, we talk about, I mentioned just now about substance requirements. So substance requirements, I believe it was introduced as part and parcel of the changes in the tax landscape internationally. Right? So Labuan has introduced what we call substance requirements. So substance requirement mainly is whether is to impose certain requirements for Labuan entities to ensure that enough substance are being put in Labuan. Okay? This is to avoid that gone were the days where people design a structure or form a structure in Labuan and there's no employee, there's no substance, there's not enough expenses being incurred in Labuan. So the substance requirement for a Labuan Islamic Trust and even a Labuan Foundation would depend on the assets of the trust asset or even assets endowed into the foundation and trust, right? So if the assets are pure equity holding, right, the requirement for the substance requirement is an annual operating expenditure of 20,000 per annum, and there's no full-time employee requirement. Okay, and on the other hand, there's also none if the assets in the Labuan Foundation and the Labuan Islamic Trust are not just pure equity holding, so they are a mix of debt securities or even real properties and so forth. Then there are certain additional requirements that needs to be considered, whereby one full-time employee is required to be in Labuan. Right? Of course, there's a lot of debate on how Labuan Trust or Labuan Foundation can comply with this full-time employee, but I think this I will reserve that discussion in a different platform. And on top of those substance requirements, there are also a requirement to comply with the management and control to be in Labuan. Right? So for this is especially applicable for pure equity holding structures, whereby at least one board meeting or one meeting in Labuan for each calendar year. There's also other requirements such as the registered address needs to be in Labuan. Okay? So for failure to comply with those substance requirements, it just doesn't mean that the structure will crumble. It's just that the income generated by the Labuan Islamic Trust or even Foundation will be taxed at 24% of its audited profits under the Lobata, or the Labuan Business Activity Tax Act. So with that, we to sum up, I think before we do a Labuan structure or even any wealth structure, tax is one of those considerations that we need to consider. Right? It shouldn't be the main consideration, But it is one of the consideration that needs to be considered, because if there are transaction costs involved and even compliance and costs involved, and at the same time the repercussion for non-compliance would also be quite severe in the current days. Okay. With that, I thank you for your time, and I think we'll move to the next session.
We've got 9 questions listed already, but I wanted to go back a little, okay? I know we went into the structure and we went into the tax and all the rest of it, but what I'd like to do is go back a little bit to look at the family considerations. And this is where I'd like to bring Elaine in, right? To talk about really when we start looking at planning for a family, does it make, you know, Elaine, in your experience, does it make any difference whether it's a Muslim family or not a Muslim family when you look at the family constitution and the family governance?
Thank you for that question, Farah. In my opinion, and I think Farah Deba will probably agree with me, is that any family, when you are leaving wealth to the next generation, needs to actually consider the governance, right? Particularly if they are leaving operating assets, especially with regards to a business. But even if it's not a business, the question is, you are leaving wealth. If it's going to be divided among the next generation, if it's very, very clear about who the legal ownership goes to, okay, that's one aspect. Then the legal ownership is taken care of. But then what about the decision-making among the next generation in how to manage the assets that are within the structure? I think that is very, very crucial. And that's where we find that quite a few families fail to consider that, and to their grief. Usually after the first generation passes or the testator passes, then the disputes happen. Yeah, because when it's very clear who owns it, maybe it will be the 4 children or 5 children. They may own it in different percentages, but how do they agree together? Is it one person? Is it the brother, the eldest brother, who decides everything, or are all of them expected to have a say according to their shareholding, or equal votes? Right? It depends on every family. And I think whether they are a Muslim family or non-Muslim family, these considerations play a part. And therefore, family constitutions or family governance is very important for the founder to put in rules now to work together with the next generation in co-developing these rules, so that the next generation knows how to make decisions together, and to put in conflict resolution mechanisms in those rules or code of conduct.
Yeah, and it makes complete sense, right? Because at the end of the day, the governance structure, the constitution embeds the ethos of the whole family. And, you know, I mean, I hazard a guess, and it might be a bit controversial, but the idea, for example, that you could have a Muslim family with all intents and purposes wanting to have a Sharia compliant wealth solution, then without a governance structure, then gets eroded. That Sharia compliance gets eventually eroded with time, unless it's embedded within the constitution, right? I mean, so, you know, if nothing else, in my mind anyway, I would think that it's more essential for Muslim families to have a very strong Islamic element within their governance and constitution to ensure that longevity with regards to that principle, that core principle.
Yeah, I would agree with you, Farah, especially if that value, that it must be Sharia compliant, is so integral and so part of the DNA of the wealth creator, of the founder, right? And if that's what is so important, then you want to encapsulate that and make sure that it's not eroded over time.
Yeah. Absolutely. And just to be clear, this is even before you start looking at which structure to choose. I mean, we have a question here about the cost of, there's a question here, what are the fees of these 3 methods? I mean, I think when that would be like not even secondary, or, you know, that is a decision way down the road. I think at the end of the day, it's an issue about getting it right in the first instance. Farah, I wanted to come to you now, if you don't mind, about, obviously as a private client lawyer and the chairman of STEP Malaysia, you're looking at a lot of different jurisdictions, right? Of course, we like to think that Labuan is one of your favorite, but obviously for the sake of your clients, you'll have to look at different options. Based on what you've seen so far, how is Labuan in comparison to other different structures, different domiciles, specifically with regards to their structures, solutions within that Sharia space?
I think comparatively, where we could look at where there is real Sharia content, right? I think Labuan is beyond comparison. Okay, the other one, of course, comparatively, it would be we have what do you call that? Dubai, DFIC, and also ADGM, yeah, Abu Dhabi.
Yes. Yes.
Yeah, but in these jurisdictions, of course, I'm not saying that there's Panama, there's also Jersey and Guernsey, where trust and also foundations are being used by Muslims as well. Basically, you have a lot of choice, right? But what Labuan offers is the fact that the Sharia content is here. You can find quite a number of Sharia advisors in Malaysia as well. Yeah, quite a number of them are listed. And as far as Waqf is concerned, it's one of the unique corporatized Waqf structure. Yeah, this was created back in 2015, kan Farah?
Actually, a bit later than that, in 2010. But for when you look at, yes, because for all intents and purposes, any foundation can be, excuse the word, Islamatized. But when you look at the ecosystem, then you're referencing, that's what you're referencing. But also our Sharia Supervisory Council, I think that's quite unique, right?
Yeah, definitely. So that's what I'm saying. The Sharia content is here. It's in Labuan. Likewise, you will have it also in ADGM and as well as the DFIC. But your Labuan Waqf, International Waqf Foundation is most unique. You know why? Because there is a difference between Islamic Foundation and LIWF. Islamic Foundation settlement or endowment is based on hibah. Whereas a Labuan International is quite a mouthful. LIWF is based on the intention of Waqf. So the akad itself is the intention to Waqf. So if you look at my structure just now, whilst Islamic Foundation you use hibah for purposes of LIWF, you don't use hibah. It's actually the pronouncement of the intention of Waqf. This is where in Islam the importance of intention is the cardinal rule. It says innamal amalu bil niyah, nothing but it all begins from niyah, right? So your intention is very important. You can have Waqf, you can actually have it in your Islamic Foundation. You can have a subset of it in there, but our LIWF is a specific built-in mechanism for Waqf purposes. So to me, it's easier to deal with. It has that mechanism, and all you have to do is your foundation is actually the mutawali, the trustee, and your charter dictates all that. So the principles of Waqf is in there already. You see? So yeah.
There's also a question here that I think, when we start looking at comparison between domiciles, let's not forget Malaysia. So there's a question from Grace here that says, what's the difference between the Labuan Trust Foundation and the ordinary trust offered by a trustee in Malaysia?
Okay, so when you talk about Labuan, the Labuan Trust Act excludes Trustees Act 1949. So therefore, the trust created in Labuan is a statutory trust. So you have all the reserve powers clauses out. You can have there's a variety of provisions that is not available for purposes of peninsular type of trust. Yeah. So that is why Labuan should be looked at as a jurisdiction for wealth management. It has got the perfect combination of, particularly for trust, you see. Whereas for Peninsular Malaysia, we have to rely on common law principles. It has not been statutorized. Yeah.
True. And there's this very popular question, okay? And this question we get asked a lot. Can a Malaysian Muslim make a will for offshore assets, right? And if that's the case, what are the ramifications vis-a-vis Sharia law?
whether Malaysians can make a will outside Malaysia for
Correct.
offshore assets, definitely yes, but it all depends on whether the testator wants to have one will or multiple will. If you have multiple one will for assets across all over the world, then naturally there is a requirement for resealing, and that's the succession issues. Yeah, you have to look at the law of the domicile again. But if you're looking at inheritance issues, sorry, I missed out on the multiple will. The multiple will, then you'll have to look at the law of the domicile and how that country actually implements the will other than just getting the letter of representation. So even if you are not a Muslim, we have a host of problems when someone prepares a will of Malaysian domicile having assets in China. So I have got requests from clients, I mean from advisors in China and Hong Kong, asking us to help them to identify certain documentations which is not actually which is not easy for the Chinese to accept, you see.
Yeah.
So there's a lot of probate and administration issues actually. So the answer is yes, you can have your wills for multiple assets, multiple jurisdictions as well. And
okay, but it sounds more easier said than done, huh?
Yeah, because that is just the process, right, Farah? But when you talk about the inheritance aspect, which is the law of substance, right? The substantive law itself, you have to look at Shariah law in its purest form and how is it being applicable to Malaysia. Perhaps I can pull out this slide.
Oh yes.
Yeah, I thought I prepared this. I somehow I thought somebody was going to ask me this question. So if you look at priority of distribution, I think this is I'm famous for this. So all my students, you know, my chambering students will always draw this, you know. Basically, you have to understand that in an estate administration, the first thing that you have to determine first what forms part of the estate. Trust assets held by the deceased is not subject to distribution. Okay, so whatever that falls within the estate, you must pass the test of solvency. It's the same thing. The law of insolvency applies. Next, how do you distribute it? So the date of death is very, very important. At which point does the liability move from the estate, from the individual to the estate? Now, in terms of priority of distribution, you must first deduct testamentary expenses, then liabilities. Liabilities can be definitely income tax. Fariz can help you with that. That's the statutory duty, and of course there's zakat for you to make payment for, and you have secured creditors, you have unsecured creditors, and you also have actually where the contracts amongst joint venture partners, you know, and things like that. So you have to actually quantify that first. Less of liabilities, then you have to look at hartas pencarian right of the spouse. Okay, these are rights in Malaysia. These are rights which is subject to a claim in Shariah court. So even if you have a contract with your spouse, it's just a matter of practice whether that contract will need to be endorsed by the Shariah court during lifetime or after death of one of the spouse. Yeah. So you then less that off, then you have the one-third bequest rule to non-heir. Remember that the rule of bequest, there are two parts to it. One is the value, which is one-third to non-heir, one-third of the estate. Yeah. So even if a will, the other thing about what you need to understand is in Islamic wills, nothing is absolute. It is subject to those rules. The one-third rule is after minus of liabilities and all that. And whatever that is stated in the will, if it does not qualify the one-third rule, then you have to get consent of your waris, yeah, of the other inheritors. As far as who the non-heirs are, it all depends first and who are your heirs. Anyone who's not listed as your heirs, of course, non-heirs. So if you decide to give, to bequeath to a stepson whom you love, who have taken care of you, so by all means, Islam allow you to actually provide them with some of your inheritance. You don't call it inheritance, like gift. Yeah, it's a gift. Then only then you talk about faraid. However, there's a lot of confusion again. In actual fact, the way I see it is in the absence of mutual agreement, then you look at the faraid portion, right? How to distribute, and that's what your rights are. But if all feel you can't agree, so be it, it will be faraid distribution. Yeah. So that's how That's why when you look at distribution, it's substantive law. When you look at whether your will needs to be resealed, not to be resealed, and things like that, those are pretty much procedural as far as Muslim families are concerned. Yeah.
And actually that makes it quite clear. But there's a very nice question here from Mercy talking about, for Hiba, is a 1/3 value applicable, or are the rules regarding Farah 8 no longer applicable?
Hibah, remember, hibah is a gift inter vivos. It must be done during lifetime. So if you so decide to give 100% to your one and only child, whom you think 20 years down the line will take care of you, so be it, do it.
Okay, and with Hiba, so this is another question that relates, this is from Andrea. With Hiba, are the Sharia compliant trust assets, is the transfer irrevocable?
Okay, Hibah and trust are two separate things, right? Okay, if you wish to transfer, the Hibah rule is that it will not form part of your estate if it was absolutely transferred. Okay, basically you have no more reserve powers. It's actually the test of Farah 8 is similar to the test of whether a creditor can have a claim or not. It's pretty much similar. Okay, so if you have reserve powers, then it becomes disputable. Now, if you create a revocable trust, then of course that will leave your other inheritors open to discussion whether
a little bit less happy.
Yeah, you know, so it all depends on your intention, what actually you mean by having a revocable trust or irrevocable trust.
Okay. Very complicated. See, I told you we left the most complicated one to the end. Eric has got a question here about the Labuan Waqf, and does it involve the Malaysian religious authority in any way? It's a good question, because obviously in Malaysia, there are states that have separate religious authority. And how does that all work together? How does that all gel?
Okay, I think you need to cover Labuan, okay, where your Waqf is concerned. Labuan Waqf Foundation is set up pursuant to the Labuan Trust Foundation, Labuan Foundation Act. In Peninsular Malaysia, Waqf is actually forming part of the state law. It being state law, therefore, falls within the jurisdiction of the Majlis Ugama. So anything to do with Waqf actually falls within the jurisdiction of Majlis Ugama Islam, whether Majlis Ugama Islam Kuala Lumpur, Selangor, Perak, Pahang, it is their discretion. It is actually within their
purview.
Yeah.
However, for Labuan Waqf Foundation, that becomes a federal issue, right?
Yes, because the foundation laws is a statute of its own. It's a standalone.
Correct. Correct. So I guess that answers Eric's question, i.e., no, the state does not necessarily, once it's properly endowed into the Waqf Foundation, I guess. So it wouldn't.
Yeah.
Okay, Fariz, you've been very quiet, and I wanted to bring you into the conversation before we go. We are 5 minutes over time, but we still have almost 120 people still online. So I think once they start dropping, we can stop. But obviously, there is still interest. Fariz, just to ask you, you know, with these changes, so obviously tax is a certainty like death. And taxation is an important consideration with regards to wealth management structures, and has been the driver for wealth management structures for a long time. But with transparency, you know, transparency in ultimate beneficial owner, transparency in registers, the common reporting system, how do you feel that this will change generically generically wealth management, or specifically Islamic wealth management?
Well, thanks Farah for the question. Very interesting. You really saved the most difficult question for the last, I guess. So the change in the international tax landscape would definitely change the approach towards wealth management. Like I said, we've gone are the days where one can use vehicles in tax haven countries to avoid tax or even to hide wealth. Right? So as for example, even in Labuan, there is substance requirements, right? that have been imposed, and also in other preferential tax jurisdictions, like for example in Cayman and even BVI, there are already substance requirements. And also another example is on common reporting standard, where you have pointed out just now. It is basically a platform where countries exchange financial account information of tax residents among them, right? And meaning that information on money is kept in financial accounts outside of Malaysia by Malaysian tax residents are being made known to the Malaysian Inland Revenue Board. So if I keep money in the UK, Inland Revenue Board in Malaysia would know that I have X amount of money in the UK. So it's vice versa, right? So in terms of this, what are the considerations that we need to look into when it comes to wealth structures, right? One of the things is the compliance obligation. So what are the compliance obligations? For CRS, for example, there are two parts. Either you are the entity that has been formed for the succession planning would need to comply with the due diligence requirements, with the annual reporting requirements under the CRS, or in another angle, it does not need to comply with those obligations, but it has to make certain declarations when it comes to dealing with financial institutions. Like for example, it wants to open a bank account, and sometimes the financial institution will give them certain forms or self-certification that needs to be declared by those entities. So again, there are, to a certain extent, there are additional compliance obligation for wealth structures. And knowing the increase in tax transparency, right? So what can we do to ensure that our tax affairs are in order? So again, documentation and also evidence needs to be in place. So this is for in any event, if the wealth structure are being questioned by the tax authorities, there must be sufficient documentation to support those structures, and as well at the same time to support the assets that are in those structures.
Yeah, absolutely. I was wondering, there's this question from Lisa to the panel, right? Can a Malaysian make a will governed by the laws of Hong Kong if he has assets based in Hong Kong, or will the will always be governed by the law of the domicile? This is nothing specifically Islamic or Sharia related, actually. So it's quite clear to say that the laws, which laws would prevail. Does it matter whether it's a Malaysian that has set this will up and that the assets are in Hong Kong? Which laws would prevail? Anyone?
Shall I?
Sure.
So in practice, I mean, the rule of private international law is that, when it comes to immovable asset, law of domicile, the law of the site of where the immovable asset is, shall apply. Yeah, law of the site. In all of the cases is the law of domicile. Now, in practice, what happened is a lot of clients have got multiple wills in respect of various assets in various jurisdictions. So if they have multiple assets, even if they were to make an application in the UK, for example, but he's a Malaysian, then most likely by declaring that he used the testator, the deceased was a Malaysian domicile, highly likely the judge or the court will require an affidavit of foreign solicitor, to provide that in the Malaysian law is as such. So there are quite a number of cases also whereby there is no such request, and then suddenly we just receive the will, and and we just have to help implement. So it all the law is very clear. You should look at the law of domicile unless there's other reasons not to.
So the law is clear, but the circumstances can be complex, right?
Yeah.
And talking about complex circumstances, also a question from Peggy here. If the settler set up a trust before he or she converted to a Muslim, will the Sharia law apply to the trust after the settler converted?
It depends on what, well, I suppose the answer would be if the settlement was done before this conversion, and the asset is no longer in his name, whether the trust can continue, because it's a living trust. It just continues. Yeah. So the religious belief of the settlor does not matter here. Yeah.
Because it's already been converted. It doesn't belong to him anymore, right?
Yeah. And even if it
In
belongs
that
to
sense.
him, and if you were to settle it into the trust via hibah or even by way of settlement, it would have not been in his name anymore, and therefore the law of inheritance doesn't apply with regards to that particular property. Okay.
And I think, you know, we're almost 5:15 now, but there is one question which I think is quite interesting, which I think we should take, like probably the last question. How can hibah be legalized? How can one avoid the issue of family members questioning the gift after the death of a donor? I mean, I think this is quite controversial. I'm not quite sure there's any possibility of settling it in that sense, like something that's clear cut, as it were. But what does the panel think?
Okay. Can I just go back to my table just now, right? That priority of distribution. So if you look at A, first you have to determine what forms part of the estate. If a property A is during your lifetime, there are trust properties, there are hibah assets that's not within your which is no longer within your in your name or control or possession, then naturally it has been absolutely transferred. Naturally, there cannot be any other claim by anyone else. No one can make a claim over it, not your creditors, not even your inheritors, for that matter. You know, but if the problem lies when the hibah document is drafted as a hibah, but to take effect after death. So sometimes, you know, you can create, to me, it's always good to be innovative, but there are basic certain principles that you just cannot be creative and just follow the rules.
Don't go too far.
Yes.
And should never go too far. Okay.
And Farah, and yes, may I just add?
Of course.
Just to add, I think as Farah said, yeah, I think the issue is a lot of it is about communication. Yeah, it may be that the donor has had a conversation with the donee. Yeah, the dad possibly, or the mom, giving to the next generation, that particular child, but the other children don't know.
Correct.
Right, and if they don't know, and later they find out, that's when the disputes tend to occur. And that's why if you have family governance put in place now, where we do deep dives with the family, we discuss these things in the past, and intentions as well. So if someone wanted to do a hibah, but to take effect after death, then this could be discussed in the family in front of everybody, so that it is made clear, right? And like Farah, you said that the Farah 8 kicks in mainly if in the absence of mutual consent, right? If everybody agrees and everyone is fine with the way the founder wants things done, then Farah 8 doesn't really have to kick in, right? I mean, you know, nobody will take each other to court.
Well, but yes, but the question is, you don't want to circumvent Farah 8 necessarily, yes, right? So that it goes into the ethos of it, right?
The ethos, yeah.
But you have the ability to give away during a lifetime, right? So you have the ability to give it. Some people would say take the risk of giving it away during a lifetime. But yeah, so you're kind of caught in that way. But, you know, to me anyway, what I have gained from this today is actually the need for Muslim families to have a stronger governance and constitution than ever, than maybe other families, because there is this element of spirituality and religiousness that the governance structure can help reinforce, maybe.
Yeah, can I just add to that? I think since we are on the topic of succession planning, I think another concept that we must all embrace, is actually succession grooming. You must start the conversation. You must encourage conversation. I do that with my children. You know, I encourage that simply because they need to understand what happens, what they have to do immediately after you drop dead. So and that conversation must be encouraged.
Must happen.
So I think we need to also create awareness that we shouldn't be shy to talk about it, and for that matter we can tell, basically how your children behave, so that could be one way to look at it. So I've helped with that question.
Thank you. I think we've still got 100 people, but we are almost 20 minutes over time. So on that note, I'd like to thank our panelists, like to thank STEP Malaysia, Deloitte Private, and all of you that's been with us, not just today, over the last 2 earlier sessions as well. We've had overwhelming interest in this series. And who knows, we might come back with something similar next year, but maybe in a different vein. I don't know, we'll see. But it's been such a pleasure working with Deloitte Private. Thank you, STEP Malaysia, for everything as well. And stay safe, everyone, till the next time. Thank you very much for joining us today. Thank you.